We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran Schultz Law.
Hi! Welcome to Legalisis. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast.
Happy birthday!
Oh, thank you! Gosh, I'm so old.
Not really. It's just an age. Number is just an age.
Still, I'm outside of the calendar already.
You look young.
Oh, thank you.
You've been in the practice of law for 14 years already. So
Correct.
my question is, where do you put your money?
Oh, wow. Okay. In a lot of different buckets.
Okay, like
But
what?
the biggest would be real estate.
Alright, so real estate. Okay. Well, for today's podcast, we're going to talk about lease.
Yes.
Right?
Correct.
For lease, what is really a contract of lease?
Okay, a contract of lease is a contract between two parties whereby an owner or a lessor allows one person to use his or her property for a given period of time, depending on the contract, and you have a lessee that would also want to borrow for a given period of time that particular leased premises.
Okay, so you have two parties there, the lessor and the lessee.
Correct.
So what are the obligations of the lessors and the lessees? So we're going to discuss this about. So we're talking about just real property.
Yeah.
Lease. So what are the obligations of the lessors?
Well, it really depends on the contract and what type of property that you are leasing.
Okay, so for example, we're going to lease a condominium unit.
In condominium units, usually there are two types, right? The commercial and the residential. So let's talk about commercial condominium unit.
Yeah.
It's actually very straightforward because for a commercial lessor, he just has to make sure that the lessor will be able to use the property for what it is meant to be. If it's meant to be a commercial lease, then the lessee should be able to get permits from the city hall because of the zoning that this particular area or this particular condominium office is okay for office space.
All right. So how about if the subject of the lease is a residential condominium
Correct.
unit?
If it's a residential, then the obligation of the lessor is to ensure that the lessee should be able to use that particular condominium unit for use as abode.
Okay.
It can be used to sleep in. What is the regular expectation for residential lease? You should be able to sleep there. You should be able to cook. You should be able to wash your clothes or any type of expectation that you should be putting into a contract.
Okay, so how about the obligations of the lessee on the other hand?
Okay, mainly to pay.
Of course.
Okay? You have to pay because the lessor will not let you use his property if you don't pay, and you have to follow the manner of payment stated in your contract. If it's stated there you have to pay every month, then you pay every month at a given time or every year, because there are some leases that would ask you to pay 1 year in advance, and then you also have to pay for security deposit. There are also instances that in your contract of lease, there are restrictions in the use. For example, if you are in a residential lease, the lessor would only want that particular residential be used by a family of 4. So if it's for a family of 4, it would be a breach already if you have 6 persons living there or even 10.
So you mentioned about some obligations already. So what are the basic terms and conditions that you usually put into a contract of lease?
Yes, okay. I can say about at least 5: term and termination, when your contract should start and when it should end, pre-termination, what happens if you can't pay, what happens if there is a breach, manner of payment, how much you should be paying, when, if there is interest or penalties if you are unable to pay. There would be the use, what type of use will be the property be going to be used for.
So why is it important that you have a term and termination in your contract of lease?
Well, for one, if you're the lessor, it's important when to know the contract will end and when it will start. For the start date, of course, you will have to give the key, right? Allowing that person to use your property. And then the end date, if you're the lessor, there are instances like you want to increase the rent. You can only increase the rent after the end of the termination if you make a renewal. Or if you are going to use the property on your own. So, at to when do you have to wait when you can use the property already? Or if there are any breaches, like what happens if this person does not pay, what happens if that person trashes the place. So you have to have some provision wherein you have a recourse against the lessee to eject that person.
Okay, so before we go to ejectment, well, which we will discuss in a separate podcast anyway.
Yes.
So, what do you usually do before you get a tenant?
Okay, it's very important for both parties actually, whether you're the lessee or the lessor, to have due diligence.
Okay, so what is the due diligence that you usually do?
Right. If you're the lessor, you may want to ask around, like if your lessee, potential lessee, will be able to pay for your rent. How do you do that? For example, you work with brokers. Your brokers should also assist you, like getting information regarding that particular lessee, where that person works. Does that person is able to pay for that particular amount of lease that you're asking for? What's the salary, if you can? What's the business, if you are asking for a really huge amount of rent? Or if it's a commercial lease, how long has the business been? Where it was previously residing, or where is the previous office? You may also want to consider asking the previous lessor what is the relationship of that previous lessor and the potential lessee, because you would know if it would be a headache for you if that person would be your new tenant or lessee.
You already made your due diligence.
Yes.
So, do you do anything when the lessee already moves into your rented property?
Of course, for example, if you're leasing residential and it's fully fitted, it makes sense that you take a picture of everything that's inside the property so you know the condition of the property. Because when the lease ends, you want to make sure that it is turned over to you in the same condition, excepting wear and tear. Also, the list of like fixtures
Yeah.
that's inside the unit. If it's fully furnished, you have ref, you have TV, you have dispenser, you can even have plates. The others would be fully furnishing a unit and you would have blinds, curtains, how many number of forks, how many number of plates. Are you willing to be reimbursed if something breaks,
I
etc.?
guess that's also a protection on the part of the lessee, also.
Correct.
Right?
Correct. It's not really one
Yeah.
way, because the lessor might say, "Oh, there's a painting that I put here," but you took a video of the whole premises and there's no painting, right?
Yeah, that's right. So, after your lessee has moved into your rented place,
Yes.
what do you do next after that?
Well, before that, you really have to have a contract, a lease contract.
Oh,
right?
yes, of course. That's important.
Yes, if you have been doing this for a very long time, leasing properties, then you can do it on your own. But, it also makes sense if you ask a lawyer to at least bless it.
Or draft the contract of lease.
Correct. And it makes sense for both parties to review it together so that, it has been mutually negotiated.
Okay, so you've mentioned already or tackled already the obligations of the parties and the basic terms and conditions that we put in the contract of lease. So, do we have to have the contract of lease notarized?
Yes, actually, under our civil code, if you are letting that property for at least 1 year, it has to be notarized. Otherwise, it would be unenforceable. It will be enforceable between the two parties, but it will not be enforceable as to the third party. Why is that important? For example, you have co-owner of a certain property, right? You have husband and wife. One the other party, you are estranged. The other party does not know that it has been notarized, but you have given an SPA before, right? So as to you, if it's not notarized, if you are the one that did not sign the lease, then it will not be binding to you. But as to the other spouse that signed it, it would be binding. But it would be difficult then because who are you going to pay, right? If it's notarized, then it helps you because it's already a public document. There could be a question: do you have to register your lease with the Registry of Deeds?
Yes. So do you?
Yeah, it depends because if your lease is really a huge amount, I mean, you're talking about you're building an office space
Okay.
in
It's good to have it
yes.
registered.
Yes, you have to have it annotated on the on the title of the unit owner or the landowner, because you want to protect yourself as a lessee that if the lessor would sell that particular land, your building or improvement will be protected. Will be the lease will be continuous. It will not be interrupted despite the change in the ownership, despite the change in, for example, you have mortgage, etc. You have issues like that.
Do you do that also with your residential condominium unit?
No, because it's a pain. If you have a condominium unit, for example, it's just 40 square meters. It's a pain to register it with the Registry of Deeds. And then if you want to sell at any given time, you have to have it removed pa. Diba? You have to have it, you have to file for the removal of
Yes.
the annotation. So it's not really practical for you to do that, especially if you're dealing with a small amount of rental anyways.
So it's advisable to do that whenever you lease on a commercial or
Correct.
big.
Large scale,
Yes.
yes.
Okay. So we have discussed all the obligations of all the parties.
Yeah.
So now here's the complication.
Okay.
So what if?
Yes, what if?
What if you have a breach
Yes.
of terms of your contract of lease, especially on the part of the lessee? Say, for example, the lessee did not pay the rent which is due on a particular month. So,
Correct.
what's the recourse of the lessor?
Yes. In your contract, you should be really careful on what is a breach. So you did mention non-payment is
Yes.
considered a material breach. So if you don't pay, it really is in the call of the lessor if he will be very strict in the implementation of his options as stated in the lease. If you don't pay, for example, you pay on a month-to-month basis, you can eject that person. Of course, you don't put it into your own hand. You can eject that person because that person is not paying anymore. But if, for example, you're looking at, you know, you've asked at the beginning of the lease, you've asked for 2 months security deposit, 2 months advance, and your lessee just didn't pay for 1 month. It's difficult also to find a lease. So, with the discretion of the lessor can think of immediately ejecting because of just 1 month period of failure to pay, or consider like offsetting because you have 4 months anyway of leeway to cover the failure to pay for that particular month. However, it makes sense for the lessor to have certain provisions to protect his interest when there is non-payment. For example, you have penalties like surcharges. You know, you have to pay every fifth of the month, but your lessee pays every 10th. So first occurrence, maybe you can make patawad. It's okay, but if it's multiple times, then in some contracts they would ask for a penalty of like 500 pesos
Okay.
if you don't
For
pay
every
on
delay.
time. Yeah, for every delay, or for or they would charge for a pro rata penalty, like maybe 3% for the month that you didn't pay.
Okay, how about water bills or utility bills. Your tenant just, didn't pay or refuses to pay the utility bills like water bills. You as a lessor, can you actually disconnect water utilities or electricity bill for non-payment?
Oh my God, do not do that. It can be a criminal case against you for a just vexation. Again, you do not put the law into your hands. You seek the help of a lawyer. You go to court for ejectment so that you can eject that particular person from your leased premises. It also helps if you are in a condominium unit. If you don't pay for the rent, and you are responsible in paying for, say, the association dues, your amenities, the use of your amenities will be cut off. For example, your RFID can be cut off. It will be difficult for you to use the elevator, right? If you are on the 29th floor, you have to walk all the way from ground floor to your unit to be able to use it, right? It's a pain. Or you have kids and you want to use the swimming pool. You can't use the swimming pool anymore because you are not in good standing.
Is that legitimate that the HOA can actually do that? Well, we can actually discuss that in our next podcast
Correct.
for the HOA rights.
And
Yeah.
what are your rights and obligations if you are part of a condominium association or any homeowner association?
Okay. So now we talk about the other provisions of your lease contract. So how about repairs? What are the obligations of the lessor and the lessee when it comes to minimal and the substantial repair of your rented place?
Okay. It makes sense to check your contract. What does your contract say? So if your contract say the repair is to be done by the lessor, then it's the lessor's responsibility. But if you're the lessor, it makes sense that you indicate in your lease agreement a certain distinction. What is a major repair and what is a minor repair? For example, in cities, like if it's in a residential area, you put threshold, like anything over 5,000 pesos would be a major repair, anything below 5,000 pesos would be a minor repair. So if you have an issue with your faucet, you need to change your faucet, that won't cost you 5,000 pesos, then it would be the lessee that would be responsible in the repair. But if it will cost a lot, like for example, like I said, in your contract, you stated that any major repair is 5,000 pesos and above. The aircon is broken, right? It's leaking, it's raining in your bedroom. It will cost you maybe 10,000 to fix the elevation of the piping. Then yeah, it would be a major repair and it will be the responsibility of the lessor to have it fixed. It also makes sense to indicate the duration of when you should be repairing. Like if you're the lessee, you may want it to be repaired in the next 7 to 14 days from the time of notice. So it depends on what's stated in your contract.
So you mentioned about terms as to the allotted time of repair. What if the repair went like a month? What is the recourse of your tenant because he or she will not be able to use your property anyway?
Right. If it's not indicated in your contract, let's add a little bit of days in the 30 days
Okay.
or 1 month. Because in the civil code, if it's 40 days or more, the lessee can ask for the suspension or reduction of payment.
Okay.
But if it's less than that, then you have to suffer for the inconvenience. Just be patient. I'm sorry. It really happens
That's tough.
sometimes. Yes. Sometimes it happens. That's why it's part of your due diligence as the lessee. Like, for example, we have a client who had an issue with the lease premises being smelly, like it smells like cigarette smoke. The lessor promised that the place would be cleared of smoke, but it wasn't cleaned anyways. Unfortunately, the lessee still accepted the key and lived there for maybe a couple of weeks until she said, "Okay, I can't live with this location because, yeah, there's already smoke." So the idea there is before you accept the key, before you live into that residential unit, everything should be in spick and span.
Right. So you mentioned about putting up an aircon a while ago.
Correct.
I remember. What if it is the lessee who actually put up the improvements, like the air conditioning? What happens after the termination of the lease? Who gets the aircon or the other improvements or the furniture like that at
Yeah,
the rented place?
that's a very good question because it happens.
Yeah.
People would want to make an improvement in the lease premises to make their life nicer. Or not even just residential. In commercial units, you make it from bare to semi-furnished,
Yes.
right? What happens to the improvement that you've made? So you look at the contract. What does the contract say? If the contract says any improvement that was introduced by the lessee during the time of the lease, at the end of the lease, it would be owned by the lessor, then the lessor owns it without any payment to the lessee. However, if it is not indicated there, now you go to the default provision in the civil code. Like if it is something useful to the leased premises, you can ask for half and half. The half value of the improvement can be paid half by the lessor if the lessor wants it. But if the lessor doesn't want it or doesn't have the money to pay, then the lessee can remove that improvement. The lessee can remove that aircon even though it will deface the leased premises. What happens if you really are sick and tired of your tenant? Can you eject that person? Yes, there are ways, there are options to do that. But it's better if you answer that because that
Okay.
already is
Sure,
litigation
yes,
court case.
okay. So let's discuss that in our next episode.
Yeah.
All right. Thank you, Attorney Marge.
Well, thank you. It was enlightening.
Yes.
Bye.